Hello, good day. Welcome once again to another episode of Kwentuhan Sessions JMBL Case Digest. This will be the 20th episode of Kwentuhan Sessions. So this is because you continued to subscribe to our channel. Of course, to be updated of the new episodes. Okay, just like this. So for this episode 20, we'll be discussing Arturo Soriano E. Santia as petitioner versus People of the Philippines as the respondent. GR number 232147, June 8, 2020. This talks about the warrantless search, more specifically about checkpoints and the plain view doctrine. So this under political law or even remedial law, di ba? Kasi medyo in those cases pareho sila, 'di ba? May convergent sila ng topic. Anyways, this case discusses about the validity of warrantless search of a person known to have a contraband from a tip obtained from an informant. So, tingnan nga natin if the warrantless search done here in this case is valid or not, even if when it comes from an informant. Okay? So, for the facts of the case, petitioner Arturo Soliano is charged with the violation of the gun ban during the 2010 election period pursuant to Batas Pambansa bilang 881 in relation to COMELEC Resolution 8714. The prosecution, through the testimonies, established that on February 11, 2020, PSI and police station investigator Tarazona and PO3 Estuya received a text message from an anonymous informant saying that a passenger wearing camouflage shorts was carrying a firearm on board a Ceres bus coming from Buranga and bound for Katiklan. Ayan. So, may nakuha silang tip yung mga police officers. So, saying that a certain person has with himself a firearm or barrel. Okay? So, the Malay Police Station conducted a checkpoint in front of the municipal plaza to verify the tip. So, acting on the tip, naggawa sila ng checkpoint. Okay? The police officers flagged down a Ceres bus, kasi yun yung sabi sa tip, and asked the driver for permission to embark. On board, PSI Tarazona saw the man described in the tip. So, nakita nga niya yung tao who was wearing camouflage shirts and inside the bus. Okay? PSI Tarazona approached the man and saw the handle of a pistol protruding. Okay, so nakalabas from his half-open belt bag. PSI Tarazona then asked the man to alight from the bus to avoid commotion from the other passengers. After inquiry, the police team identified the man as Arturo Soliano, a security officer of the municipality of Buruanga. Arturo, however, failed to show his authority to possess the firearm. Consequently, a search on the person was conducted and yielded a loaded caliber 45 pistol and 2 magazines of live ammunition. So then Arturo was informed of his constitutional rights, arrested, and was brought to the police station. There, Arturo and the seized items were turned over for investigation to PO3 Estuya, who made the inventory of the items. So, yun. Acting on the tip, they made a checkpoint, and from that checkpoint, they saw the person described on the tip in the tip. And then, dahil nga may nakita si PSI Tarazona na baril or yung handle ng baril ay medyo nakalabas, 'di ba? Siya yung pinababa. Then after a search, nakita nga na meron siyang 45 and a magazine of live ammunition. Okay? So Of course, Arturo was charged and was found guilty by the regional trial court, and upon appeal, also upon his appeal, was also found guilty in the court of appeals. Okay, court of appeals. Okay, they found him, Arturo, guilty of um, violating the Omnibus Election Code as amended by Republic Act 7166 in relation to the gun ban resolution of the COMELEC, which is COMELEC Resolution 8714. Okay? Because he was denied of his appeal from RTC and CA, he now then petitioned or appealed through the Supreme Court. Okay? So seeking his acquittal. Arturo contends that he cannot be held liable under COMELEC Resolution number 8714 since the issuance is an administrative resolution which cannot be a source of penal liability. Okay, so hindi naman daw penal law yung gun ban. Okay, so he should not be charged of a crime. Okay, so yan. Arturo maintains that the conduct of the checkpoint was illegal and that it was irregularly done because the police officer failed to put up the necessary signage and warning to the public. Okay? So, hindi daw tama yung pagkakagawa ng checkpoint. And lastly, consequently, Arturo's arrest was illegal and the items seized from him are inadmissible as evidence against him. So he is contending since his arrest was illegal, therefore the search and seizure upon his body was also illegal because of the rule or the doctrine of the fruit from the poisonous tree. Okay, the primordial doctrine of the fruit from the poisonous tree. So that was his contention. Okay. So the issues in this case is number one, whether or not Arturo has waived his right to question the illegality or legality of his arrest. Okay, so pwede pa daw ba na i-question kahit upon appeal sa Supreme Court yung legality ng kanyang pagkaka-aresto. That's issue number one. Issue number two, whether or not the checkpoint and subsequent arrest and seizure was valid. Okay? So, kasi yung pinagmulan ng arrest, yung checkpoint. So, pag invalid yung checkpoint, invalid yung arrest. And then, pag invalid yung arrest, invalid din yung seizure. So, kaya magkakonect-connecta sila. Okay? Number three, yun nga, whether or not warrantless search was valid. And lastly, whether or not Arturo was not properly informed about his charges. Okay? So Arturo is contending na iba yung charges na nilagay ni prosecution dun sa kung saan siya na-convict. So kaya yun yung issue niya sa number 4. Okay? So let us discuss the rulings as ruled by Justice Mario V. Lopez and the Supreme Court. So for number 1, Justice Mario V. Lopez and Supreme Court said that yes, Arturo has already waived his right to question the legality of his arrest. So hindi niya na pwedeng i-contend or sabihin na illegal yung kanyang pagkaka-aresto. Okay? So Justice Mario V. Lopez said, Arturo questions the legality of his warrantless arrest to dispel the jurisdiction of the court over his person. Notably, Arturo entered his plea during arraignment and actively participated in the trial. He did not move to quash the information on the ground of illegality of his arrest. Okay? So, nag-participate ka naman, di ba? May nag-plea ka you entered your plea and you actively participated in the trial without having said or without raising the issue on the illegality of arrest. Okay? So, yun. Consequently, the trial court obtained jurisdiction over him. It is then too late for Arturo to question the legality of his warrantless arrests at this point. Okay? Since he actively participated during the trial and he already entered his plea. Okay? Kasi ang 'di ba, ang remedy nun kapag may illegality ng arrest, edi sana nag-motion to quash siya. Okay? Motion to quash. The court has consistently held that any objection by an accused to an arrest without warrant must be made before he enters his plea. Otherwise, the objection is waived. Okay? Since he already entered his plea, wala na. Okay? Wala nang chance para um, i-contend or i-argue yung legality ng kanyang arrest. Okay? So, it should be made before he enters his plea, before an accused enter his plea. An accused may be stopped from assailing the illegality of arrest if he fails to challenge the information against him before his arraignment. And since the legality of an arrest affects only the jurisdiction of the court over the person of the accused, any defect in his arrest may be deemed cured when he voluntarily submitted to the jurisdiction of the trial court. Okay? So for this ruling, what is Justice Mario V. Lopez teaching us that in order for you to contend or to argue about the legality of arrest, you must do it before entering a plea. Otherwise, if you forgot to contend or to argue the legality of the arrest, then therefore you will be stopped. Okay, you are no longer to question the validity of your arrest, of the accused's arrest. Hindi naman ikaw, di ba? Hindi naman kasi ikaw yung, wag naman sana ikaw yung i-arrestuhin. Pero the accused's arrest, okay, kapag it is done or after the plea or during after the arraignment. Okay? And also, there must be no active participation on your part. Okay? Kasi nga, if you actively participated, meaning pumapayag ka that you are within the jurisdiction of the court, di ba? So, bakit ka nakikipag-participate kung sabi mo naman, eh, walang jurisdiction yung court. So, dapat hindi ka na nakapag-participate. Okay? Or you questioned it before entering your plea. Okay? Otherwise, you'll be deemed waiving your right and therefore you voluntarily submitted to the jurisdiction of the trial court. This is what Justice Mario V. Lopez is teaching us in this first ruling. So again, Arturo has already waived his right to question the validity of his arrest. Okay? Number two, Justice Mario V. Lopez in the Supreme Court said, yes, the checkpoint and the subsequent arrest and seizure was valid. Okay? So, Justice Mario V. Lopez said that the checkpoint conducted by the Malay Police, was pursuant to the gun ban enforced by COMELEC. Okay? So, siyempre, di ba, pag may election, may gun ban, okay? Or bawal magdala ng ng firearms, okay? Checkpoints which are warranted by exigencies of public order are conducted in a way least intrusive to motorists, are allowed since COMELEC would be hard put to implement the ban if its deputized agents are limited to visual search of pedestrians. So sinasabi dito yung purpose or yung rationale ng checkpoints during COMELEC gun ban. Okay? Those who intend to bring a gun during election period would know that they only need a car to be able to easily perpetrate their malicious design. Okay? Kasi kapag wala daw checkpoint, okay, kung hindi mo papayagan magkaroon ng checkpoint during gun ban, eh, tatakasan lang kayo ng mga yung mga criminal, okay, na merong baril by simply just riding a vehicle. Okay, since hindi alam naman nila na hindi sila checkpoint. Okay? So, yun yung reason kung bakit pwede ang checkpoint during COMELEC gun ban. Okay? So, Justice Mario V. Lopez also added a jurisprudence to this case to further bolster the Supreme Court's decision. Okay? He said that specifically for inspection of passenger buses in Saluday versus People is instructive. Okay? The inspection of passengers and their effects prior to entry at the bus terminal and search of the bus while in transit must satisfy the following conditions to qualify for a valid reasonable search. Okay? So, hindi naman ibig sabihin na mayroong search, lahat yun valid. So, of course, if there is an intrusion to your right, okay, if there will be intrusion to your right, of course, there should be requirements set, okay? May requirements muna yon para maging valid yung intrusion ng iyong karapatan, which is number 1, first, as to the manner of the search, kung paano gagawin yung search. It must be the least intrusive and must uphold the dignity of the person or persons being searched, minimizing, if not altogether, eradicating any cause for embarrassment. Okay? So, ang dapat daw gawin is hindi yung masyadong nakakabahala or yung nakakahiya, okay? And also, it must be least intrusive. So, hindi siya masyadong nagre-restrict sa'yo, okay? Yung search, di ba? So, also, when you choose a person to be searched, hindi naman yung parang pagkatapos ng search, pagdududahan na siya ng katabi niya, 'di ba? So, kasi syempre kung hindi naman, tama yung search or wala naman talaga siya, baka mamaya nakakahiya naman din yung mangyayari doon, okay? So, if not altogether eradicating any cause for public embarrassment, humiliation, and or ridicule. Siyempre, anong feeling na ma-search ka ng isang police, 'di ba? Na parang yung tingin ng lahat parang akusado ka na agad. So, i-minimize daw 'yun, okay? Second, neither can the search result from any discriminatory motive such as insidious profiling, stereotyping, and other motives. Okay? So, hindi ibig sabihin na, ikaw, puro ka totoo, di ba? Ikaw yun, ikaw, isa-search ka namin. Okay? So, dapat, as much as possible, kung hindi lahat sila isa-search, dapat hindi naman masyadong judgmental daw. Okay? In all instances, the fundamental rights of vulnerable in identities, persons with disabilities, children, and other similar groups should be protected. Okay, as much as possible, yung mga persons mentioned dito, hindi sila, pati yung rights nila ay ma-uphold din. Okay? Third, as to the purpose of the search, it must be confined for ensuring the public safety. Okay? So, kaya ka nga nagsa-search kasi nga alam mong may contraband sa loob or may possibility na may contraband doon. Fourth, as the evidence seized from the reasonable search, court must be convinced that the precautionary measures were in place to ensure that no evidence was planted against the accused. So, it should be further investigated whether how the said contraband or said gun or said drugs, di ba, got into the pockets or to the bag of the accused, di ba? Kasi marami ngang mga pulis, excuse sa mga pulis na okay, pero di ba may mga times may mga pulis na graduate nga ng agriculture. So, pag graduate ng agriculture, magaling magtanim. Yun yung sabi ng prof ko. Okay? So, yun yung joke niya doon. So, sana nagets natin yun. Okay? So, yun. So, given those conditions, okay, the third, okay, related to this is the third issue or whether or not the warrantless search made to Arturo was valid, was already valid. Okay? So, the court said that yes, the warrantless search made to Arturo was valid under the plain view doctrine. Okay? So, tama yung checkpoint at nung pagkakita kay Arturo, okay, yung nakita nila na may protruding doon na handgun, it is valid through the plain view doctrine. Okay? Justice Mario V. Lopez said that During the conduct of the checkpoint, PSI Tarazona saw in plain view a firearm protruding from Arturo's belt bag. Under the plain view doctrine, objects falling in plain view of an officer who has the right to be in the position to have a view are subject to seizure and may be presented in evidence. Okay? So dapat, okay, kitang-kita niya, okay, or may view talaga siya doon. Hindi siya natatago or hindi. Kung sana hindi 'yun nag-protrude, okay? Um Hindi yun plain view doctrine, 'di ba? Kasi nakatago nga. Pero dahil nag-protrude yun, plain view, kita niya kasi. Okay? So, sabi dito, meron siyang position na kung saan dun sa position niya, nakita niya na nandun yung gun or yung contraband. Okay? Also, Justice Mario V. Lopez um, said that this doctrine, the plain view doctrine, requires that a law enforcement officer in search of the evidence has a prior justification for an intrusion or is in a position which he can view a particular area. Okay, so meron either alam niya na itong taong na to ay may dala, okay, kasi may prior justification siya, or kita niya kahit wala siyang tip, nakita niya agad na merong bitbit or may dala na contraband yung accused. Okay? Letter B, the discovery of the evidence is in plain view is inadvertent. Okay? So, hindi niya sinasadya or wala siyang ginawa by any way para mapalabas yung contraband. Okay? So, hindi niya inalog, hindi niya pinabuksan yung bag, and so on. Okay? Dapat kitang-kita lang talaga. Okay? And number 3 or letter C, it is immediately apparent to the officer that the item he observes may be evidence of a crime, contraband, or otherwise subject to seizure. These requirements are present in the case. Okay, so just as I always point out, okay, Justice Mario V. Lopez always parang alak method, okay? He gives us the answer, lay down the legal basis, and then applies the facts to the legal basis, and then his conclusion again. So, ganun din natin dapat sagutin yung bar exam natin. Okay? So, here, Justice Mario V. Lopez, applying the plain view doctrine to the facts of the case, he said that the police officers of the Malay Police, after receiving a report that a person was in possession of a gun, conducted a checkpoint in coordination with the municipal election officers. Upon contact with the subject Ceres bus, the police asked permission from the driver to board the bus. On board the bus, PSI Tarazona came across the firearm. When in plain view, he saw the firearm protruding from Arturo's half-open belt bag. Thus, the police officers had the duty to arrest him and confiscate the contraband in his possession. At the time of his arrest, Arturo was committing an offense by being in possession of a firearm during an election gun ban. Okay? So, yun nga. Since it was protruding and since carrying a firearm during a gun ban is a crime or is a violation, okay, therefore the search was valid because of the plain view doctrine. Okay? So last, Arturo contend that he was not properly informed about his charges, but the court said no. Arturo was properly informed about his charges. Okay? Arturo was accused of violating COMELEC Resolution 8714, which is the gun ban. The charges against him is in relation to BP 881 and the amendatory law of 7166. Okay, it is settled that it is the recital of the facts of the commission of the offense in the information, not the nomenclature of the offense, that determines the crime charged against the accused. The designation of the offense given by the prosecutor is merely an opinion and not binding on the court. Differently stated, the crime is not determined by the caption or preamble of the information, nor the specification of the provision of the law alleged to have been violated, but by factual allegation in the complaint or information. So, what is Justice Mario Lopez is pointing out here that maaring hindi naman talaga naka-spell out or naka-caption na ito yung crime mo, pero syempre ang titignan talaga is yung mga allegations or yung mga elements na nandun sa information. Not necessarily, it will not follow necessarily the caption. Okay? Just Mario V. Lopez said that the facts pleaded in the information constitute the offense of carrying firearms outside residence or place of business under Section 261 of BP 881. Okay? So, thus, Arturo was duly apprised of the charge against him. There is no violation of his constitutional right to be informed of the nature of the accusation against him. So, ang sinasabi kasi ni Arturo dito, ang violate ko lang naman 8714 Why am I being charged of BP 881? Kaya lang kasi in relation nga talaga yung 8714 sa BP 881. Okay, yung illegal possession of firearms. Okay? So, kaya na-charge pa rin siya. Kasi sinasabi niya yung Comelec Resolution 8714 or the gun ban it's not a penal law. Okay? But BP 881 is. Okay? So, ang charge kasi sa kanya, yung violation na 8714. Sinasabi niya, bakit siya na convict na under 881, okay? Kung ang charge sa kanya ay yung gun ban lang. Okay? So, sinasabi ng court na magka-relate yun yung election gun ban tsaka yung BP 881. Okay? So, walang Arturo was still properly informed of his charges. So, sinasabi niya kasi merong disparity sa violation. Sabi ng court, walang disparity doon. Magka-related naman kasi sila. Okay? So, yun yung sinasabi ng court doon. Okay? If you will read the full text, of course, again, I do still recommend you reading the full text. Okay? If you have the time, because in this case, Arturo Soriano, aside from what we have discussed, Justice Mario V. Lopez expounded on the validity of checkpoint and bus searches. Of course, bago niya syempre na-conclude, okay, na valid nga yun, syempre nag-expound pa siya. Justice Mario V. Lopez likes in his cases to cite jurisprudence or cite laws that would support, of course, his decision and the decision of the court as a whole. Okay? Pero sige, discuss na lang natin. In this case, other doctrine would be, as decided by Justice Mario V. Lopez, said that while in transit, a bus can still be searched by government agents or security personnel of the bus owner in the following 3 instances. Okay, so kailan nga ba pwedeng magkaroon ng bus searches? Number 1, first, upon receipt of information that a passenger carries a contraband or illegal articles. The bus where the passenger is aboard can be stopped en route to allow for an inspection of the person and his or her effects. This is no different from an airplane that is forced to land upon receipt of information about the contraband or illegal articles carried by the passenger. So, dapat meron kang prior information, okay? Meron kang tip. Yun nga yung nangyari dito. Kaya nahuli si Arturo kasi merong tip. Okay? So, hindi basta-basta magkakaroon ng search. Meron dapat na reason, which is the tip, to search the vehicle, okay? To aboard and search the vehicle. Number 2, whenever a bus picks passengers en route, the prospective passenger can be freeze and his or her bag or luggage can be subjected to the same routine inspection by government agents or private security personnel as though the person boarded at the bus terminal. This is because unlike an airplane, a bus is able to stop and pick passengers along the way, making it possible for these passengers to evade the routine search at the bus terminal. Okay? So, it is also valid na, 'di ba, paminsan-minsan eh, may pumipick up pa or may kinukuha pang pasahero daw ang mga bus on the way, 'di ba? Yung kunyari may mga malalapit na sa mga bayan-bayan tapos mula dun sa hindi siya nakapunta sa terminal, dun na lang siya sa gitna, sumakay, okay at sumabay. So, meron pa din valid search o puwede pa ring i-search daw yung taong yun, okay dahil siyempre merong, safety or security reasons behind that. Kasi baka nga naman alam niyang search siya dun sa terminal, eh, kung alam niyang hindi siya search sa gitna ng daan, eh, di dun na lang siya. So, pero dahil meron namang authority na puwede siyang ma-search dun kahit nasa gitna ka sumakay, at least mag-iisip-isip pa rin yung criminal or yung accused, okay? Third, a bus can be flagged down at a designated military or police checkpoints where state agents can aboard the vehicle for a routine inspection of the passengers and their bags or luggages, okay? In both situations, the inspection of passengers and their effects prior to entry of the bus terminal and the search of the bus while in transit must satisfy the following conditions to qualify as a reasonable search. Okay? So, ito yung diniscuss natin kanina. That the search must be the least intrusive, it must not cause embarrassment, humiliation, or ridicule. Second, can neither the search result to a discriminatory motive such as insidious profiling, stereotyping, and other similar motives. Okay? Hindi yung puwedeng namimili ka lang basta may tattoo or basta mukhang, "Uy, ang pangit mo, 'di ba? Parang baka makatingin, So, yun. So, hindi dapat daw gano'n, okay? Number three, as to the purpose, it must be confined to ensuring the public safety. And number four, the evidence seized from the reasonable search must be convinced that that precautionary measures were placed to ensure no evidence was planted against the accused. Okay? So, ayan. Medyo mahaba-haba pa to pero this is of course taken from the case Saluday versus People as cited here by Justice Mario V. Lopez. Okay? So as to summarize, sorry, in this case, Arturo Soriano versus People, Justice Mario V. Lopez again taught us that the legality of arrest should be contended or argued before entering a plea. Otherwise, you have waived your right to contend the legality of your arrest. Number two, checkpoints can be validly made, okay, in pursuant to the jurisprudence cited by Justice Mario V. Lopez, Saluday versus People. Basta in cases for bus searches, okay, again, the following conditions must be complied with. Number one, it must be the least intrusive and must hold the dignity of the person or persons being searched. There should be no discriminatory motive such as insidious profiling, stereotyping, and other similar motive. Number three, as to the purpose of the search, it must be confined to ensuring public safety. And number four, that it must ensure that no evidence was planted against the accused. Okay? And for plain view doctrine, what are the requirements? Is number one, the law enforcement officer in search of the evidence prior justification for an intrusion or is in a position which he can view a particular area. So there must be a prior justification for the intrusion and or position where he can view or nakikita niya na may contraband talaga. Number two, the discovery of the evidence in plain view is inadvertent. So hindi niya sinadya. Okay, hindi niya tinadyakan, wala siyang ginawa. Okay, on the part of the police officer doing or a government agent doing the search. Okay. Letter C, it is immediately apparent to the officer that the item he observes may be evidence of a crime, contraband, or otherwise subject to the seizure. Okay. And number four, the fourth thing that Justice Mario V. Lopez teaches us in this case is that um, it is not the caption or the title of the case does not uh, is not determinant of the crime to be charged talaga. It is what is inside the allegation of the information or the elements, okay? Kung saan yun yung that would be the controlling portion of the case to which the accused is charged. Okay? So that is Arturo Saliano versus People of the Philippines. I hope I help you to understand this case. And of course, continue to subscribe. As per last checking, we only need 15 more subscribers, 1-5, para ma-reach yung 400 subscribers, and therefore we could then again release episodes 21 and 22. Okay? So, yun, maraming salamat po at continue sa pakikinig and happy aral sa ating lahat. Thank you.